Ladies and gentlemen, live from the St. John's University campus, we have attorneys Gary Forster and Eric Boughman from the law firm of Forster, Boughman, Lefkowitz and Lowe. Gentlemen, I turn it over to you.
Well, good afternoon, or I should say good evening, everybody. This is Eric Boughman. I'm joined by my partner, Gary. And tonight we will be talking about latest trends in asset protection. And some of the things that we're going to cover here are cryptocurrencies. That's a hot item, and we're going to lead off with that. And we're also going to talk about domestic asset protection trusts and foreign trusts and other ways to engage in domestic asset protection using entities and exemptions and so forth. So got a little technical issue here. Tony, are you able to flip to the next slide?
T, hold on. We're a little disarrayed in New York. Hold on one second. So I wanted to give an intro. We have a technical problem. What we're going to do today, an asset protection seminar involving cryptocurrency. We apologize.
Gary, can you speak into the phone, please?
Yeah, I'm trying to. We're doing a simulcast presentation, so we're both in a conference room and we're online with 30 or 40 people. So we have a boutique firm, a corporate tax, an international boutique firm in Orlando, near Orlando, Florida, and we go to various CPA groups with tax and asset protection related type seminars. And this is just one that we give on cryptocurrencies and foreign trusts. And today, my partner Eric Boughman, who's the expert of cryptocurrencies, is going to talk about that. I wish we could get on a better audio, but I think we're going to have to actually do it through my phone. So that being said, did you have any additional intro, Eric?
No, I think we can go ahead and flip to the next slide, which is going to give us an overview of the what we're going to talk about tonight. So I'm going to start us off and give everybody an introduction to cryptocurrencies. That's Bitcoin, Ether, and things of that nature. There are now several thousand cryptocurrencies. And what we're going to do is we're going to try and make it a little interesting here and tie cryptocurrencies into how you might use that as an asset in an asset protection plan. And it's not that we're necessarily advocating for that. We're not financial planners, but it provides a nice example on how you, because of the nature of the asset, on how you might utilize it in structuring both onshore and offshore asset protection. Separately, if you're interested in cryptocurrencies, you want to know more about the law on that, there is a seminar that's available that we've done here in the office with another one of our attorneys, Brian Page. And Brian and I recently did a national webinar on the law of cryptocurrencies, and we covered a national law that is being proposed in various state legislatures to create a uniform law to regulate cryptocurrency businesses. So if you have any interest in that, feel free to reach out and shoot an email or a phone call my way, and I'm happy to discuss that more. And without any further ado on our overview here, let's dive into our cryptocurrency discussion. So cryptocurrencies are, the idea of digital cash has been around for a while, but what makes Bitcoin so revolutionary, and Bitcoin is the first digital currency, so I may bounce back and forth and you refer to virtual currency or digital currency or cryptocurrency or Bitcoin as one of those, and I'm going to be talking about the same thing for our purposes tonight. Bitcoin started in 2008 as a concept and has spawned literally thousands of other similar copycat currencies. What makes Bitcoin so revolutionary is that it really is the first form of digital money or a digital money like object that actually works and can be transferred where you don't have an issue with copying files. So prior to Bitcoin, you had a situation where, if anybody remembers the old Napster music download issue, what happened with Napster is folks were sharing music via computer, and in old copyright law with the first sale doctrine, if you went out and you bought a cassette or a record or a CD and you resold that, you didn't have to pay royalties on the resale. That's the first sale doctrine. And the idea is once you already had paid for the asset once, you transferred it, only one person could be in possession of that CD, or one person could be in possession of that cassette tape of the Bee Gees that Gary still has in his car. And what we have with online files is that you have a situation where you could transfer a song file and then also keep a copy on your computer. So that's why Napster didn't work. It didn't work legally. We have the same issue with digital cash. So you have cryptocurrencies. Prior to cryptocurrencies, the issue was if you wanted to transfer money, if I wanted to transfer a digital dollar from my computer to somebody else's computer somewhere in the world, there existed still the possibility that that file could remain on both computers, and there was no way to account for that. So Bitcoin was the first of these cryptocurrencies to use cryptography. It's math functions to secure transactions in order to transfer value without keeping it on multiple machines. Once one value leaves one person's possession, it leaves one person and it derives in another person. Hopefully that's not too confusing, but let's go ahead and flip to the next slide, and hopefully this will become clearer. Just gives it. And by the way, if there's questions, we'll keep an eye out online with our attendees. And Gary, if there's any questions in the audience, please call them out. Like I said, Bitcoin was the first of the cryptocurrencies. There's now two forms of Bitcoin. There's two forms of Ether. That's another big one. These are up here on the slide, shows other popular cryptocurrencies, and actually it's a little bit dated, although they've gone up and come back down. Market capitalization, which is just the value of the tokens and dollar value that are outstanding in the marketplace. By far the most popular of these are the Bitcoin and Bitcoin Cash and Ethereum and Ethereum Classic. So next slide, please. Up, back. Next slide. Let's see. Okay, let's stay here. So, all right, so I'm going to run down some of the features that make Bitcoin unique. One, decentralization. There is no headquarters for Bitcoin. Bitcoin operates through a public key and a private key system. So you can give anybody your public key, and we have an example of that in your materials that you have, and we'll see one on a slide coming up. So anybody can have a public key, and that's essentially your address. It's a digital, it's a number, it's a digital address, and you use that in order to send value, Bitcoin value, from one user to another, or one wallet to another, and we refer to Bitcoin wallets. The way you do that is you first enter in the address that you want to send the Bitcoin to, and then in order to activate the transaction, you have to enter in a private key. And it's a long series of digits that are unique to every wallet and every user. When you enter that private key, then it sends the Bitcoin through the blockchain network, which we'll talk about in a minute. And the blockchain updates so that you are now, you have a little bit less Bitcoin, and the person you send it to has a little bit more. But there's one of the things that's revolutionary, several things are revolutionary about Bitcoin and cryptocurrencies, is there's no centralized authority. Traditionally, if we wanted to transfer money, it was either done through a bank who updated a ledger, or it was done through credit card processors who acted as the middleman in a transaction, or some escrow agent, And in the internet era, everybody knows Elon Musk now from Tesla, but one of his earliest ventures was PayPal. And PayPal was the way that people transferred money on the internet back in the early days of the internet. And PayPal just acted as a central authority or a central middleman to make sure that PayPal would hold on to the money that you were sending to make sure you got the goods that you were supposed to receive, and then get the money to the third party. And so PayPal acted as an intermediary for that transaction. So Bitcoin in 2008 eliminated the need for a central intermediary. It also is a secure network. It operates through cryptography, and there's been several cases in the news about exchanges and wallets being hacked, but the Bitcoin network has not been hacked. It's highly secure, and the network itself has remained impervious to hacking or other outside security issues. I talked about the intermediaries here, the fact that there are no intermediaries, and what makes this really especially for our accounting folks here, Bitcoin it operates through the blockchain, which is a ledger, and that's all it is. So if you think about when you go to when you go to your bank and you say, okay, bank, maybe I have an account at Bank of New York, and Gary has an account there, and I want to transfer $10. There's not somebody at the bank that goes and takes $10 out of the one little area of the bank and carries it over to the other area and puts it in Gary's section. All the bank does is update the ledger, and if there's multiple banks involved, it's basically a similar process. They're just debiting one side and adding the other side so that the ledger is constantly updated. What Bitcoin's another revolutionary feature of Bitcoin and blockchain is that this is all done without an intermediary, but that's what the blockchain does. The blockchain is a fancy online digital ledger that gets updated through a community network instead of a third-party intermediary. So there's no intermediaries. The transactions on the blockchain are irreversible and immutable. They can't be changed once they're entered onto the blockchain. The only way to undo a blockchain transaction is to have another transaction that essentially does the reverse of the prior transaction. And I should also mention, by the way, that the blockchain is discussed in connection with Bitcoin, but all cryptocurrencies generally operate on, they may be different types of blockchains, but they all operate on a blockchain. And that blockchain is what really makes this revolutionary. So it's called a blockchain because it's a series of blocks of data that are updated, and each block connects to the prior block through this cryptographic functioning, and those blocks are linked together in a chain. And so when you look at the series of blocks and the data contained in those blocks, right away if there's been any tampering, because the blocks won't match up in a series. If you alter one block because of the cryptography, it alters all the prior blocks. So that functioning makes blockchain transactions immutable and irreversible, not subject to outside manipulation. All you can do, once you send, if I have a Bitcoin or a fraction of a Bitcoin, and we go out to 8 decimal places on this, so you can go pretty small. If I send a fraction of a Bitcoin to somebody, once that transaction goes out the door, I can't reverse it. There's nobody to call. Again, there's no central authority to call up and say, hey, I need you to undo that transaction. There's no chargebacks. It's appealing to merchants in that respect. The next feature here, Bitcoin's being exchanged for other currencies. In fact, when the cryptocurrencies probably were at the peak of popularity, which was last year, right at the end of 2017, coming into early 2018, there were several new in vogue online cryptocurrencies that you couldn't actually get directly. The only way to get those cryptocurrencies was to either know somebody who had them and figure out something of value to trade for them, or to actually convert Bitcoin or some other cryptocurrency to acquire that particular currency. Ripple is one. We saw that in the earlier slide. Ripple runs on the XRP network. It's been in the news previously as a potential having a potential use by the banks or a potential substitute for MoneyGram. And if you wanted to acquire XRP, the coin token of the Ripple network, you had to do so by exchanging Bitcoins or some other token of value. Bitcoins are said to be pseudonymous, or the transactions are pseudonymous. And what that means is that everybody can go on the block online. You can go to blockchain.info and you can see transactions on the blockchain. It's a public ledger, viewable by everybody. But all you can see are the transactions with the numbers, the addresses that I mentioned earlier that are engaging in those transactions. But unless somebody tells you what the address is, or unless you know what someone's address is, then all you have are addresses. So some businesses, like for a while, I don't know if they still do it, the United Way used to publish their address right on their website. And so if you wanted to send United Way money via a digital currency like Bitcoin, you could go on to the United Way website and get their Bitcoin address and send them Bitcoin. And they just left that out there. There's no risk in leaving that out there. Nobody could take any Bitcoin from them with their address. All they could do was send Bitcoin to it. So I always make the joke when I'm returning something that I purchased on a credit card, and the merchant or the employee wants me to sign the receipt to refund money to my credit card. I always tell them, look, I don't want anybody using my credit card for any purchases, but if anybody ever wants to put money back on or give me a credit, if I don't sign it, that's fine. Go ahead and feel free to put that money back on there for me. So that's similar with the address. So if you have somebody's address, you can send them Bitcoin, but you can also identify people through the address. So another example is in the growth of the last couple of years of cyber ransom. And cyber ransom has grown because, in part, in connection with the growth of cryptocurrencies like Bitcoin, because now a cyber criminal who freezes up or locks your files and wants you to pay them a ransom to decrypt those files can just give you an address without giving you any bank information. They don't have to say mail a check to me at this location or send money to this bank, which is easily traceable. They can just give you a Bitcoin address and say send money to this address, and you send money, and then they get the money and the Bitcoin, and nobody ever knows who's behind the address. And by the way, these addresses, you can create a new address. They're simple to create. There's websites that allow you to do it instantaneously. And so you can have new addresses for every single transaction. And so you'd never be able to trace. If you want to hide behind the address and not reveal your identity, it's possible to do that. Now, there's some more advanced mechanisms that people use to go and trace transactions through the Bitcoin network, try and figure out who's behind an address or where that address eventually dumps as far as maybe a bank account or somewhere where it links to. But there's also countermeasures that include the name escapes me, Bitcoin tumblers, essentially, where it's a mixer, Bitcoin mixer, where people can mix multiple addresses and Bitcoins together, and you pull your Bitcoin back out of these mixers with your address being essentially untraceable. Now, the other side of the transaction, like I said, was you have the public key, but you have the private, or you have the public address, and you have the private key, and the private key is what enables you to send value through the Bitcoin network. So if you have both the public address and the private key, you can link up the private key to the public address, and you can send the value. But if you only have one, if you only have the public key, then you can remain anonymous behind the key. So that's why it's called pseudonymous. You can see the transactions, but you can't actually see the folks behind them. And fairness, as far as government manipulation, this refers to the fact that the Bitcoin in particular is unique in that it has a schedule written into the software code that provides for a certain amount of Bitcoin to be released into the Bitcoin or blockchain system over a period of time. And so it's controlled. It's an anti-inflationary measure, and it's a control mechanism. How is that released? Well, I'm glad that you asked. It's actually released through miners, and people have heard that term. Maybe you have some clients who are engaged in Bitcoin mining. It's gotten more popular, or you can join a group or a consortium that engages in Bitcoin mining. And what happens with Bitcoin mining is there's a two-part function there. One, the miners are the folks who verify the transactions on the blockchain network, and we'll get to that in a minute. But understand that the reason you don't need intermediaries is because you have a network that's updating through a community-based verification system that's backed by the miners. And the miners provide electricity and computational power in order to do that. And as a reward, they receive Bitcoin tokens. And oh, cool, we flipped to the next slide. So the miners receive these Bitcoin tokens as payment. And over time, this started a few years ago, a miner might receive a few hundred Bitcoin for a particular transaction. And now, at last, I think it was maybe a 12.5 Bitcoin that's received. And by the year I think it's 2120, all of the Bitcoin that are ever going to be distributed will be distributed. And that's partly driving why people think that by acquiring Bitcoin now, it will have even more value in the future because it's a limited quantity. And there's a set amount that will be released into the Bitcoin blockchain network. Now, so up on the slide, you see our next slide here is on the actual blockchain, and everybody I'm sure has heard of blockchain. This is a hot word, a hot concept now. It started with cryptocurrencies, but it's been applied in several other facets. Delaware has a blockchain network for updating shares of stock. And I think I just saw that there's now a bond release that's going to be tracked on a blockchain. And the blockchain it's a database, and it's really it's a fancy ledger. And so you folks are familiar with how a ledger operates, except the revolutionary aspect of the blockchain is that this ledger is not maintained by any one central authority, but instead by the community. And it's the community of Bitcoin miners in the case of Bitcoin. And so anybody can, with enough computational power, can sign up and link their computer to the Bitcoin blockchain and provide computational power for mining. And what happens essentially is that every time there's a block that needs to be added to the Bitcoin blockchain, remember the block has data in it, and that data is comprised of transactions, people sending Bitcoin to different addresses, and you fill up a block of data and you want to add it to the blockchain as a new link in that chain. In order to have that verified as being accurate and true, it needs verification through the miners, and that happens by a complicated mathematical problem going out to all of the miners in the network. And one miner solves that problem and then broadcasts the answer to everybody else in the network. And once that miner solves the problem and everybody verifies that that answer is correct, then the chain gets added to the blockchain network. And so what's the math? Essentially, I like to use the analogy of a square root. If I asked you to figure out without a calculator or a computer, but just by hand, the square root of 456,789, that will take you a while to figure out that transaction, what the square root is. But once you figure out what the square root is and you broadcast it out to everybody, then everybody else in the network can pretty easily verify, yep, that's right, you've got the proper square root, that's the answer, and that's the verification to add the information onto the blockchain. And as a reward for doing that, if you're the miner who solved that problem, you get Bitcoin. Some other blockchains will work differently. Some are what's called either a closed blockchain now, or a semi-closed or semi-permissioned blockchain. And the banks, for instance, several banks have been working on potentially either private or semi-private blockchains or semi-permissioned blockchains, where only the banks will be involved in it, and they will have a different control mechanism for updating the blockchain. But for our purposes here, for most of the tokens that you'll see folks talking about, that's how that system works. And in Bitcoin in particular, it's public. Anybody can join it, and anybody can try to solve problems for tokens. Next slide, please. All right. So we're going to get into, we're going to walk you through how a Bitcoin transaction works. Earlier, I mentioned the wallet. There's several different types of wallets. This can be, it can literally be a paper wallet. It can be done on your computer, on a phone. You can have, you can use, some folks use exchanges like Coinbase or another exchange to store cryptocurrency. And basically the wallet is wherever you store, we say store the tokens, but you're not really storing tokens there. You're storing the information that allows you to send out the private key that corresponds to the public address to update the blockchain ledger. So if you think of it like that, you're not really sending anything to anybody. You're not sending files. That's why you don't have the double spend problem. You know, two tokens in the same place at the same time. You only have one person in possession, because really it's just a simple blockchain ledger that's updating everybody's value in the network. And by you manipulate that ledger with your public key, your private key, and that information is stored in your wallet. So next slide, please. All right, so this is just a little graphic here that sort of walks through what I've just talked about. And hopefully I still have everybody with me, and we're learning something here. So the first slide shows somebody putting the software onto their computer or their phone. Again, you can do some of this by hand. I'll show you in a slide or two. We have an actual wallet. And you generate an address online, and then that address, that third graphic there right above the arrow on the top right, that's what a public address will look like. And so you plug in that address. If you want to send somebody Bitcoin, or if you have somebody you want them to send you Bitcoin, you give them that public address. They plug that in, and that's normally now done through a QR code. So a lot of times you just use a scanner and a QR code, and it populates. That's that little crazy looking thing. It looks kind of like a scanner code, and so you put that in there, and then you'll be asked to enter your private key. You can enter the private key. Again, this can be on your computer or on your phone, and it sends it through the Bitcoin network at the blockchain ledger. And when the blockchain verifies the information you sent, and when all the miners verify that the math problem that links that block to the chain, and they verifies the integrity of that block, the blockchain ledger gets updated, and your transaction now goes, we could say goes hard, or your transaction is now complete, and the person to whom you sent or from whom you received Bitcoin now also sees that transaction is completed. And that should take, in most circumstances, it should take about 6 to 12 minutes, I think was the original idea on the Bitcoin network. Interestingly, last year, when Bitcoins were at somewhere near $20,000 in value for one Bitcoin, that's what people were paying in dollar value, it was taking upwards of 12 hours to complete a transaction. So a lot of work to do as far as efficiency. You know, Bitcoin was supposed to revolutionize transfers of money by making transfers borderless, enabling people to do it without the cost, the time, and the expense of an intermediary. But a lot of these transactions, it still takes time because you're running through this limited capacity network, and a lot of folks are still using intermediaries, so there's still a cost involved, and it can be fairly significant, somewhere, you know, upwards of a couple percentage points. Can we go to the next slide, please? All right. So different ways that you can acquire Bitcoins or other cryptocurrencies, but we'll stay with Bitcoin because that's the most common. There's exchanges, I mentioned that earlier, and you can link a bank account similar to like setting up a PayPal account. You can link a bank account with an exchange like Coinbase and buy and sell cryptocurrencies that way. You can also, there's peer-to-peer markets where you can buy and sell cryptocurrencies either online or you meet people in person. And I've talked to folks that are in other countries where they actually, there's like that website Meetup where people actually will list, or like on Craigslist, and you show up and somebody just gives you, you give them whatever currency or value you're going to give them, and they transfer you Bitcoin, and you're standing there at the same time, and that's how you acquire it. Other ways are through actually a financial transaction. So if you accept payments, don't know if there's anybody in our audience here who accepts Bitcoin for payment, but that's another way. And then the other way that people acquire other currencies, not Bitcoin, but other newer cryptocurrencies, and that's through initial offerings, and they're referred to as initial coin offerings, or ICOs. Sounds a lot like IPOs. These have been in the crosshairs of the SEC over the past year or so, reputed to be rampant with fraud. You can imagine, thousands of people now, computer geeks who have figured out that if you create it, they will. What's the line from the Kevin Costner movie? If you build it, they will come. If you create it, they will buy. And so folks have come up with all different types of cryptocurrencies besides Bitcoin, such as a currency to trade diamonds, a currency for alcohol and tobacco sales, a currency for fundraising. I've talked to folks that have all these different ideas. They want to create a blockchain with a currency, and it's going to be used for a specific function. And so they say, well, we're going to create this currency, and we're going to make our own blockchain, and we're going to issue this many tokens, and we're going to do it at an initial value of X. It sounds a lot like an IPO, except they call it an ICO, initial coin offering. And up until about a year ago, this was completely unregulated. And there's still some question now over whether or not the SEC has authority, or whether the Commodities and Futures Exchange Authority has authority over these. But now it looks like the SEC is really taking the lead, and it's cracking down on people in the U.S. Engaging in ICOs. It's still going on offshore, and if you're an offshore entity such as a Cayman Islands company or somewhere offshore, and you sell initial or make initial coin offerings or sell tokens to folks through ICOs, one, there's question on what the SEC can do with somebody outside the country, and if you're selling it outside the country and you're not selling it to U.S. citizens, then again, there's a question of the SEC's jurisdictional authority. So people are getting around it that way, and I've heard of people still buying into these tokens, but be aware that a lot, some are legitimate, but there's a lot. This is just an area that's rampant for fraud. There's a reason why the SEC regulates this stuff. I put there again the securities implications. The SEC is going to look at these things like securities. They meet the Howey test. Howey actually goes back to the old days of orange groves. And it was actually a company called Howey. It was the Howey company outside a little bit west of Orlando, where Northerners would come in the summertime, and they saw the beautiful orange groves, and they were offered an opportunity to buy in to own a little piece of their own Florida orange grove. And the orange grove was managed by the Howey company, and Howey pooled all the resources together to manage and cultivate the orange groves, and any profits that were derived were then split among the various owners of the little sections of orange grove. And even though this involved real estate and oranges, and it didn't seem like something that was really similar, like a share of IBM stock, the SEC got involved, and the case went all the way to the Supreme Court, and the Supreme Court set out a test where essentially if you are selling some If you are selling an investment in some collective asset or shares, it doesn't have to necessarily be paper shares or securities. It can be a share of real estate such as condo developments, or in this Howie case, orange groves. If you're selling an investment in a group investment and you're pooling the resources and pooling the profits, then it'll be treated as a security. So be aware that you're going to have securities implications with anybody if you have clients who want to engage in IPOs. So, or ICOs, excuse me. Next slide, please. So we talked about different types of wallets. I mentioned a little earlier that the wallet is where you have the public and the private key. So right here on this slide, and you have a paper copy of this in your materials, I believe, as well, you see an actual Bitcoin paper wallet. You can go generate one of these online. Actually, the web address is right on there, bitcoin.ars.is. And the little block there with the ink in it that looks like the Rorschach test is your QR code. And you put your scanner over the QR code there, the middle, the QR code that's further to the right, that's the public address, and that's where you'll send your Bitcoin for this particular wallet. And then if you own this wallet, you would then use the code on the left, which is the private key, to send your Bitcoin somewhere else. And then this would become, the idea of this wallet and this long code will play into the seminar later when we talk about holding assets in foreign trusts and other mechanisms for using things like Bitcoin for asset protection. This is an example of a paper wallet. Now you see the long string of numbers there, that's the public address, and the long string that's the private key. You could memorize that private key theoretically. People have done that, and that would be referred to as a brain wallet. And so you wouldn't have a piece of paper. You would just keep that in your head, and when you want to send Bitcoin, you would just type in that long string of data, or that long string of numbers there, and actually numbers and letters. It's type in that long string of characters, and you'd be able to send your Bitcoin. This can also be stored, again, on your computer, in the cloud, or in hardware or cold storage, and that just generally refers to putting it on some type of electronic storage device and then disconnecting it from the internet, which is highly recommended, especially if you have a large value. Next slide, please. Okay, so we wrapped up. Hopefully that gives you a little background on Bitcoin and blockchain. Big takeaways for cryptocurrencies in general, and Bitcoin and blockchain, and what all the hubbub is about is it's a ledger. It's the blockchain ledger. It's this mechanism of keeping track of everybody's interests on the blockchain, and it's all done without any central authority. So it can't be, there's nobody to go bribe, there's nobody to go call for help, there's nowhere where you can go and sneak in and make a change, because everything is public and it's all updated and managed by essentially a community, and that community in the Bitcoin blockchain network is the community of miners. And so if you can think of blockchain as just a very fancy, secure ledger and database, I think it'll make a lot of sense for when folks in the news and when you're hearing things in business world where people are talking about managing things like real estate and bonds and diamonds and gold coins and other assets on a blockchain network. It's just a network, a ledger for keeping track of those assets. And thank you very much. I hope I didn't lose too many people. If you have any other questions on this, again, please feel free to give me a call at the office or shoot me an email. And then I'm going to turn it over to my partner, Gary, and he's going to lead you into some of the asset protection issues.
Okay. Now you're experts at Bitcoin. Usually we do the asset protection first, and we get into Bitcoin, but Eric has a prior engagement. I think it's okay. It's good background. Did anybody have any questions on more or less how it works? Because it doesn't matter. I don't know. But no, I'm not a Bitcoin expert, but I would tell you what's interesting about this Bitcoin is, I don't know if you just got it from Eric's lecture. It's not the Bitcoin. It's not the money. It's that they take this way that they keep track of the money, which is called the blockchain. So, you know, you make a deposit or you make a withdrawal, so to speak, you move this money around on this ledger. That ledger is very, very usable in many industries, because what it does is it's let's say you have a banking transaction and someone needs to verify the transaction, right? So the bank usually goes in and says, okay, the money hit the account, or it's some person going in and looking at an electronic deposit or something like that. This is different. This is a way where everybody on this blockchain kind of verifies, okay, it's okay, independent. So it's not the coin that's so interesting, really. It's this software called the blockchain, which is going to start to be used in all kinds of other industries because it's very accurate. It's a great verifier. So what we wanted to get into was, how do we, first of all, how does asset protection work? And then we can kind of, because it's kind of an interesting topic, Bitcoin and asset protection. But we, you know, that's the sexy part. This is the CPA part, asset protection. You know what I mean? Okay. So, yeah.
Is it true that when you transact Bitcoin via blockchain, you don't know who the other party is? You're not aware of.
It's totally anonymous.
Right.
They have that public key and the private key. So you're just putting your cash, your Bitcoin, into their public key. What's interesting about
Gary, I didn't quite hear the question, but if you can repeat the question, if you want to throw one out there, I can take a question if there's one too.
No, that is totally anonymous. You don't know who you're transferring Bitcoin to.
Yeah, it is. There's some ways that people, you know, the government should love this because it theoretically is traceable. But you know, the folks who want it to remain anonymous are figuring out ways to keep it anonymous. So right now it's a cat and mouse game.
So right now, but it's pretty much anonymous, right?
That's right. Yeah, right now it is. That's why it's so popular among darknet and the criminal underworld. It's obviously got more purposes than that, but that's why it's so popular.
Right, but the tricky part of it is, so if someone gets your private key, there's no one to ask, is this a CPA in New York asking you questions to verify it? That's it. You use all one. There's no human intervention. No, someone took your private key and shifted it to their other account.
Suppose you die. You're the only person who knows.
You lose it. It sits in the account. Eric may know who gets it. Eric, what happens when someone dies and no one knows about the account? Where does that Bitcoin go?
That Bitcoin, and that has happened a lot. People have lost their addresses. They've lost computers on airplanes, and things have been stolen where the wallet is on there, and they probably turn in phones and they don't even realize it. There's the estimate of unclaimed or unused Bitcoin is in dollar value probably in the tens or hundreds of millions of dollars. And so the answer to that question is that if somebody dies and they haven't passed that information on to somebody, it is gone forever. So that's a big issue now in estate planning, is your digital assets, not only access to various accounts for photos and Facebook and everything, but your digital, any digital currencies you have to account for that. You really should be going back to any clients and reminding them that they need to account for that.
So it's sitting in a private key that no one has access to, right? Because the person who had access died, and there's no one that they pass the password to.
Yeah.
Now, Gary, you can tell you later how you can get that information to a trustee and put it in a trust. So that's one thing you could do.
So the important thing is to know how to have access to your assets.
Yeah. Yes, it's interesting. To really spread. Any more questions? Oh yeah.
Yes, some companies are Bitcoin
payments.
Do they know who are making the payments?
No. probably, in that case, it's just they know the customer and then money comes into their private Bitcoin account. But I don't think they care how it comes in.
So they would be able to identify this coming from.
I don't think they care. You know what I mean? If the customer says, I am Joe Blow, I want to C12A. How do I pay? I want to pay by Bitcoin. The Bitcoin shows up at the airline in that account. They don't know where it came from. They don't get it. And that's why it's a criminal. You know, the criminals use it because it's enough.
It's a payment of Bitcoin that fluctuates on a minute-by-minute basis,
The value,
right?
the value,
The value fluctuates.
or falls, depending on the way you look at it.
In the market, it fluctuates, right?
Yeah.
So if I paid, let's say, use the 10th of Bitcoin, it could change in 10 minutes to a different value.
Yeah, it's not stable. That's not
stable.
stable.
Very volatile.
I think it's very volatile. I'm not an investor in Bitcoin. Eric called one of them. We should have invested in it. He said that this, what was it, Eric? Ether? Ether was $1 and then it was like $5 million.
Yeah, Ether actually has a purpose beyond currency, and there's a good chance of all of these that Ether could be the VHS that survives. Ether and maybe Bitcoin.
Yeah, so a few will survive. Any more questions? Okay, you're all set, man. You can go to your next event. Sorry to keep you waiting.
No issue. Have a great night, everybody.
All right. Thank you.
So the next thing we're going to talk about is asset protection. We would have a beautiful. We have the slideshow in front of you, some of you, but we can't get this thing to work. It's you know, sometimes they're too good. You know, if we had a blackboard, it'd probably be better. You know, because what happens is, what our tech guy is asking, where's the cord? Where's the cord? But it's a very complex, you know, remotely controlled thing. And that's probably we just don't have to do it. I mean, I don't have a clue. So let's talk about asset protection. Does anyone have an idea of? I usually give out my book, but I think some of you have some kind of. What is asset protection? What does it do? Is it hiding? Is it running? Is it no? Asset protection is basically using exempt assets and entities to make yourself unattractive in litigation. Does that make sense, everybody? So basically, what happens is you use LLCs, trusts, and assets that are not available to creditors. When the sky is blue and you don't have any claims or litigation or problems going on, and then if something happens in the future, you become exposed to litigation or creditor, you don't lose what you have. So it's not at all hiding or running away or anything like that. We have a little overview at this page here, asset protection basics. And so our firm operates in a world where we do asset protection all over the world. We do entities all over the world. In this exemption, let's go over it. Title. So in Florida, husband and wife can title something by the entirety. If anyone's familiar with what that is, I'd be impressed because they don't have it anymore. What that means is the English says that when you pay the dowry to my daughter, I'm going to give you, I'm going to provide the family gift, but the gift is going to be held by the entirety. That means by husband and wife, jointly and not separately. What that means is once an asset goes into the entirety of the marriage, if one spouse is sued, the asset is not available to the creditor. Right? If both spouses are sued and the plaintiff wins the case against both spouses, it's available. You don't have this. I don't believe you have this in New York at all. Some states allow in personal property, some states allow in real estate. I don't think you have tenancy by entirety. So that's titling protection. not available to you unless you use an entity to do so. So if you say, okay, I have a client, they've got a big, let's say, bank account, right? And I'd like to do some basic protection. So instead of them owning the account jointly under New York law, where if one of them is sued, they lose out the account, we're going to take the account and we're going to put it into a Delaware LLC. And Delaware allows tenancy by the entirety. So we take the LLC and we drop it into tenancy by the entirety. Now, if one of the spouses is sued, the asset is not available because it's held tenancy by the entirety. Because you have the box, you have the LLC box held tenancy by the entirety. The account's in the box and it's not available. That's titling in a nutshell. Yeah.
But you have an ownership and
If the spouse is it.
right. So you lose the case. Does the person get have a cloud on the entirety from the point of view that when that is ever sold, they're entitled to the piece that the spouse owns?
No, it doesn't work like that. So it's not lienable. It's not available in any way. In the sense you're sued by the entire state, then you guys would have to be Delaware entity too. Here's how, but there's an interesting aspect to it that very few people take into consideration. The entirety is a 5-factor thing from the English common law that basically says that you have to buy the property together, you have to title it together, everything has to be together. So what happens when there is a judgment against husband and it has a 20-year duration, right? And then wife dies. The entires are broken. So then they can say, I don't see it. It doesn't happen no more. But that's your issue on the entirety. You have to follow the entirety. There's some interesting cases on it. For instance, like let's say wife goes into a marriage with a big bank account, right? And then she gets married and she says, I want to put my husband on the bank account. I want to call it tenancy by the entirety. It's not a tenancy by the entirety because you have to open it together, you have to title it together, you have to do the whole thing together. It's a little tricky. It's not going to be that relevant to you guys, but when you see people opening accounts in their names or buying property in their own name, it should be a red flag. That's probably not the way we want to go about it. That the reality is that most lawyers kind of focus in on the local jurisdiction and don't really shop LLCs for what's the best LLC, what's the best property. But that's kind of what asset protection is. We're actually setting up structures where what's the most protected for this particular home. The next thing is exemptions. New York does have a lot of exemptions. So exemptions are assets that can't be reached in litigation. So for instance, I think New York has a life insurance scheme where if you buy life insurance, you're as the owner of the life insurance, that asset is exempt from your creditors. It's just inherently not available. The only way that can be exposed is if you had an exposed asset, and then you got into litigation and you moved that exposed asset, you sold it, you got cash, and you bought an exempt asset. That's called fraudulent transfer. So you can actually unwind an exempt asset or an exempt entity with fraudulent transfer. If you have questions, just let me know. Like a lot of this stuff branches off in other areas as well, but it's good to kind of get the basics. And then you have trust. Does anyone know why, how trusts work and why they're protected? Trust was formed in the 15th century. So what they said was my son was going out. Is going out, and I'm going to empower my friend to protect my son, his financial interest in this money. So the friend has the right to move the money around, to manage the money, to distribute the money, but not to use the money itself. That's the trustee. That's called legal title. They can move things around, they can do whatever they like for the benefit of my son. So the son has beneficial title. Can the son reach the asset? Can the son manage the asset? No. It's beneficial title. So what happens, this is the trust fund baby syndrome. You never heard that. So you have a trust fund baby. They have the trust. They draw on the trust. The trustee gives them money when they want. If the trust fund baby gets sued, is the trust available in litigation? Oh, you haven't? It's not available, is the answer. It's not available. Because the way it's set up properly, the way that trusts work are, the trustee is given discretion to make distributions. And if the trust fund baby gets into trouble and gets sued, the trust says, no, I'm not going to make any distributions. And the plaintiff can't make them. The plaintiff has no control over that trustee to get the trust asset. That's how the trust fund baby works. And it goes from generation to generation. You guys are tax CPs, some of you tax CPs. So where's the federal, the U.S. Tax code exemption? What is the greatest loophole for estate tax? What do we do that Canada doesn't do? Does anybody know? You set up an irrevocable trust, which goes on from generation to generation, right? The way the estate tax works is you're taxed on what you have when you die, right? You're also taxed on what you give away when you're alive, but not trust. Once you put the money in the trust, you pay the gift tax, or you pay the estate tax if you owe it, right? That trust can survive generation to generation and never pay the estate tax. Canada got rid of that in a little while. They didn't like that. But that's I don't know if that's going to change. But in our country, that's our big loophole. But it's not talked about much. But that's generation to generation. It doesn't, it's not tax. If it makes income, it's tax. But not something to the estate tax. Oh yeah. It's got to be the dot. Absolutely. I'm talking about discretionary trust. Because in the discretionary well, that's the problem. You trust the termination date where it says, because a lot of clients want to say, okay, well, my kid turns 30, I'm going to distribute a third of the trust, and he turns 40, another third, and then the rest when they're 50, whatever. What's the risk of that from what we're talking about? Well, if the kid is going to get the money at 30, right? I sue the kid. I just have to wait till 30. I get the money. You put the trust corpus at risk when you make it a mandatory distribution, when you write it up. So the plan sits there and waits for that distribution and absolutely can actually step in front of the beneficiary to get it. So it's not always a great idea to make distribution mandatory. And the trend is actually away from trend discretion. And then we'll talk a little about LLCs. What do you guys? How long do we go? How long? Till 8 or 9. Okay. You just tell me when, because I can go for hours and hours. You're not asleep yet, so I'm feeling good.
Gary,
the last thing we'll talk about. Yeah, I'm still on this entity. The last thing we're going to talk about is LLCs, which of course New York has. Every state has an LLC now, and we do use them in asset protection because they're much better than corporations. And we talked about the title issues of trust. So we're on the next slide now, so charging order protection. So if the trustee decides to successor trustee, you can, whatever you say, the trust. So the beneficiary can choose, the trustee can choose, anyone you want to choose. And now we have protectors, where if we're afraid of a trustee and we want a last veto right by someone else on distribution, you can write that person. And the protector can actually choose the next trustee, which is kind of a cool way to do it, actually. So if you use an institution, you use Chase as your trustee, but you don't know who Chase is going to be dealing with it. I want to put my buddy in as protector, and it works pretty well. So the next thing, we're on this asset protection with LLC. I can pretend I'm not doing it. Does anyone know the difference between corporation and LLC? I know this isn't. So corporations, right? Old school entities, shares of stock, bylaws. If a shareholder is sued, is corporate stock protected? If you've got IBM, can they take it? Yes. Yes, they can. They can take it. And that's true with even a small S corp. Corporate stock is a mistake unless there's some very specific reason to use corporate stock, like you think you're going to go public, which is, less than 1/10 of 1% or whatever of company. So what corporate stock offers is inside protection. So if the corporation does business, the owners are not liable. That's why we incorporate inside protection. The activities of the company don't make the owners liable. The problem is if an owner gets sued, they lose their corporate stock. They lose their shares. LLCs, however, don't work like that. LLCs say, okay, we offer inside protection. We say, okay, whatever goes on in the LLC, the owners aren't liable. The business liabilities are not the owner. Same as the corporation. But with the LLC, if an owner gets sued, the LLC interest, the equity, is not available. Should not be opening corporations. Because, first of all, there's no advantage. Second of all, you don't get this protection over equity. It's only subject to lien. You can't take the LLC membership interest and you can't take the assets of the LLC.
So that's why it would be better if you wanted to do tax as a corporation, be an LLC.
Make the S election and go to the corporation. Yeah, the tax is not relevant anymore. You can choose the tax. Everyone aware of that? Any questions? Okay, so the next slide is charging order. So what I said was an LLC member, that they call them members, that's an owner. An LLC owner is sued. So the plaintiff is trying to get a charging order, a lien on the membership interest, right? What does that mean? That means if a distribution is made, that the creditor can take the distribution. Can't take the stock, can't give them the assets, but if distributions come out, they go to the creditor of that asset. That's much better than a corporation, where actually the shares are taken. That's pretty much what it says. There is a comparison between Spencer trust provisions versus LLC. So you have to keep in mind that the LLC is subject to lien, right? So I don't get sued. And there are chinks in the armor of the LLC, which have been caused by what's known as a single member LLC. You only have one of them, right? Versus a trust, where if the trust is set up properly, it's very hard to breach the trust. There's no liens, there's no taking of trust assets. It's It's very, very strong if it's set up on a clear day. A lot of times you'll find that clients refer to the LLCs and they refer to the trust interchangeably. You know, they'll ask about their trust, what they use their family LLC, type of thing. Comes up all. Okay, Tom, I'm on the next one. Asset protection with LLC. No, it's called where to form the LLC. Oh, I see. There was a slide with a guy on the tour, and it said corporations have annual minutes. LLCs don't have to have annual minutes. And you had mentioned that the flexibility of taxation. If you're a corporation, you can't be taxed in a partnership. For a corporation, you're done. You're C or S, right? If you're an LLC, you can make the partnership. You don't have to make the election. The default is the partnership. If you want to be a partnership, you might as well be an LLC, or if you want to be an S, you just make the S election. The next is where to form the LLC. So what I had a little bit to at the beginning was not all the states are the same.
Let me ask you a question. If you want to be an LLC, why would you need the option to be set up an S corp, which is a pass-through also, and LLC is a pass-through? What's the difference?
Well, you get into the whole section. Oh, so you're dealing with the S corp section of the code, 1300 section, versus the partnership section. So, for instance, you're not subject to self-employment taxes, right? If you go S, you can't have preferred stock. You can't have one partner with a preferred right to distributions over another. You can't be an S. So you have to work through which is most advantageous to the client. Typically, if it's an active business, the S is more advantageous than the partnership. If it's passive, like in real estate investment, the partnership is more advantageous.
Going back to the strong deal, it says here that another benefit of the corporation is less paperwork and relaxed administrative requirements. What does that mean?
That means that there's no annual limit.
Whether it be a good
Operating.
operator.
Yeah, that's true.
Because it might as well operate.
You know, it's a good point, actually. Great point. Because with the corp, you had a very defined entity. You had a corporate statute that talks about the rights of the shareholders and how governance works. But with the LLC, it's pretty open-ended. You basically make up your own rules in the operating agreement. So that's true.
And minority shareholders will have a bigger problem. Minority owners will have a bigger problem with the LLC than they will with
if they don't have their rights written out in the operating agreement. That's typically true. You typically don't have the rights. You don't have full shareholder rights. Some states do, but you're right. You're absolutely right. You make your own rules of the LLC, so it's a little more complicated. So that's why you find a lot of clients go with corporations.
And the LLC can also give a manager the rights over the members.
Well, that's like the board. That's like the board of security. That's true. No, but you make your own rules. It's very tricky for people who want to do themselves. It's not to be done yourself, the LLC. The reality is it is done by a lot of people themselves, but it shouldn't be. You can start passing down espresso. I see heads full. Okay. All right, so let's go to the next page. So the next page was where to form. So most people don't understand how different all these LLCs are. Courts want to reach assets, right? Someone sits through a trial. The court's sitting there, it's a week. And somebody loses the trial. The court wants the assets from the loser. If at the end of the trial the defendant says, everything's in trust and I've got this LLC structure, the court doesn't really know what to do. It's like a little embarrassing. So that's why we have a lot of cases where the courts have tried to reach through asset protection from it. You're not going to be the favored party when you lose the case and you tell the judge, I'm sorry, judge, you're not going to reach it. So when you form an LLC, for instance, the statement you should say, charging order is the exclusive remedy. So you can only get a lien. A few courts have said where the statute didn't say it was the exclusive. Like this is how idiotic it is. The statute in say Colorado says if you win a judgment against a member, you can get a charging order on their interest. The reality is when they wrote that statute, you can only get a charging order on the interest. There's nothing more beyond that. That's the remedy. But the judges say, oh, it doesn't say only a charging order. So there were some foreclosures of LLCs. So all of a sudden, several states like Nevada and Delaware and Alaska say, oh, no, it's exclusively a charging order. The plans can get nothing more than the lien on it. So you want to look for a statute that says that. And then the other issue is the single member LLC. A bankruptcy court in Colorado was looking at the assets of a woman named Ashley Albright, who's a movie star actually. And she had several LLCs, and she said these are not available to the creditors in bankruptcy. Because the statute says they can only get a charging lien. And the court said, well, that's true, but I don't like that. So the bankruptcy court has a lot of power and says that the idea behind the charging lien is to not affect another party. Are you ready? Okay. That's what I said when I first read it. The idea was basically they had these partnerships, right? And one partner would get sued. And the idea was that suit wouldn't disrupt the business by someone else coming in and being owner of the business, so they could only get a lien. That's the charging order. That was kind of how it initially came. It has nothing to do with how the LLC statute is written. It's written the way it's written. But the bankruptcy court said that's what the purpose was. She doesn't have any partners, so we're taking her interest and we're taking all the assets. Then it happened in Florida too, the Homestead case. So if you want to start to try to move the client away from the single member loan, we don't know where that's going to land, but it's probably going to you're probably going to be required to have an additional member. What we do, if it's a tax planning issue, you just create trust for the kids. You add the trust for the kids onto the family and the partnership or whatever entity you're working with. That's not. If it's a business and it's a solo person, you have to look at your options. Because what happens is if they get in a car accident or they have some kind of personal liability, they can lose business as a single member. It's only 7. So you better off. Did you get dessert? I just want to. Okay.
But what I'm thinking about, you better off though if it's only one person with an school as opposed to the single member.
No. The problem with the S corp is it's a corp, so there's no argument. If you get sued, you lose the shares. The corp is the corp. It's honestly the corp. There's no reason for the corp. The reasons are so limited that basically, 1 in 1,000 companies should be corp. It just there's no reason for it. And what do people do? They don't know. That's what there are more corps than LLCs, right? It's just turned in Florida. There's more LLCs, but there's still a lot of corps. They do it because they don't know. That's why they do. There's absolutely, I can tell you, it's not really mysterious. It's not a close call. You shouldn't be corp. But there should be more courses for accountants about corps. Yeah, got that. We do a full seminar on LLC. We can come back to you. We'll make sure the day before that this thing's rolling. Okay? It's the first for me. You know what I mean? I have to put it in the
But
Bible.
if it's a single owner investment property,
Yeah.
then the preferred entity would be a trust.
You know, you got a good question. Because, because it triggers a lot of stuff. What happens is, so let's say you have a single person, not a married person, right? So you can't see the TV in Delaware. You face the single member LLC. What we've been doing is what's called the asset protection trust. So 16 states, it's a little later in here, we can skip to it. 16 states says you can form your own trust. England said in the 15th, 16th, 17th century, you cannot form your own trust. If you form a trust where you benefit and you're sued, it's not protected. So in the 80s, some former British colonies said, no, we want all your money. So we're going to make a law that says you can make your own trust. And it's protected. That's the offshore asset protection. You make your own trust. It's a huge flow of money offshore. Now 16 U.S. states want the money. And they said, no, you can make your own trust. Right? Now, we'll hit some cases where they dissect those trusts. But if you're single, right, and you can't share an LLC, and you can't be tested by the entire legal life, you might want to start acquiring things in an asset protection trust. It's a little cumbersome though, because you really have to have a trustee in a protected state. Financial planners are not a fan. So you have your financial planner in Manhattan or whatever, and you say, I'm going to form a Nevada trust because I'm single and I have a lot of life exposure, and my trustee is in Nevada. Really, you should have an account in Nevada too, but your financial planner might not be able to charge you for an account in Nevada.
But then your property is, say, in New York.
Yes, the real estate. It's not a bad, you could take a shot at that, but real estate's very tempting to judge. If you're here, the real estate's here, and the plaintiff's here, even though you've got an entity that's away, they're very tempted to take it. And that almost sets this Wells Fargo. We're one page away from it. So, Tone, I'm on choice of law issues. So, what do you think? So if Delaware says we protect a single member LLC, right? It's a law, it's a statute you form there, and that's the law governing that entity, right? Florida says you can take the single member LLC, you can foreclose and take all the assets. Where are you going to form your LLC? Single member LLC? Not something. Delaware. You're going to form it in Delaware. Because the Delaware statute is a Delaware statute, the Florida statute is a Florida statute. You've got a Delaware entity, and it's not a Florida entity. It's very disconcerting for the judge, okay, because what are they going to do? It's a different statute. It's a different entity. Okay. Now, that's called the internal affairs doctrine. So here's where it came up. Like, we do a lot of deals with New York Council. New York Council always wants to use Delaware corporations LLC. Because that's the tradition of the Delaware federal statute, and Delaware says you don't have to have annual meetings, right? New York says you have to have annual meetings. Well, internal affairs doctrine, which is that the internal affair of that statute governs its operation, says we're going to respect the internal affairs of Delaware. New York says we're going to, and you don't have to have meetings. That's the internal affairs doctrine. Now, does that internal affairs doctrine, what it says in each statute, apply when it refers to the protections of the members? I think it does. I argue with my partner on it. I think it does. I mean, it's like the Delaware nickel or the Florida nickel or the Colorado nickel.
If you have a Delaware LLC corporation, etc., you're doing business with New York.
Yes.
Don't you have to qualify in New York?
Yes.
Don't you then become subject to the New York law? You
do on your operation. But is your entity now in New York LLC?
Delaware LLC.
Well, I'm going to tell you what somebody said. So if you go to the next slide, this is Wells Fargo, right? So Wells Fargo involved this kooky woman who indebted herself for $64 million, and then she started transferring everything to offshore LLCs and moving stuff around. Actually, she had a great homestead protection, and she messed that up too. And one of the issues reviewed by the court, now these are bad actors. These are people who are trying to escape a credit. But that's where we get a lot of the law, because the judges will actually guide us as to what they can. So he says, okay, you've got a Nevis LLC. This is a prior Nevis LLC. I wrote a section of the new one. It's improved entity. But this is a Nevis. She has a Nevis LLC where she has some assets. She owes all this money. And the court says, no, you're here. The account's here. The cash is here. We're going to treat this as a foreign
in Florida.
not for operation.
No, it's a Florida LLC doing business.
No. We're going to treat it as a Florida LLC. As a Florida LLC. Because as a Florida LLC, she's a single member. She loses the LLC.
That was a Florida court.
It was a Florida court. With the money right there. It's very hard for them to deal with that. We form a lot of foreign trusts and a lot of foreign LLCs. And we generally recommend with foreign trust LLCs that the money be held offshore. Okay? And also, it's usually a part of a larger plan. So they have a foreign trust, you may have several domestic trusts, depends on the person. But for that money, if they really want to make sure it's protected, the money should be offshore. That way, the judge doesn't have jurisdiction over the trustee or the money. And this was an LLC, and she walked right into it. I mean, she owed a ton of money. She was a bad actor, and this guy was going to do whatever he could to get the money. I don't like the decision, but I understand why it's important. I don't know. I use Nevis. Yeah.
Now, if you don't qualify in the state you're doing business, you have no standing in court.
That's right. It depends on the claim. That's right. You can't at any time qualify. Yeah, that's not as big an issue. They just make you, what they want are their annual fees. So you apply to qualify, and then you pay it back. That's how they get the fee. You can't operate court. This other case, this J.P. Morgan, is a case where the litigants were in Arizona, and the defendant said, you won your case, but my LLC is in Colorado, and the property is in Colorado. So the Arizona plaintiff tried to get a charging order and foreclose in Colorado. And the court said, no, the Colorado statute does not allow foreclosure. So in this one, it was that the entity was in its home state. To their respective. That's in a nutshell. Whereas with the prior one, she was really a bad actor dealing with a foreign entity. They just disregarded it. The next slide is risks with single-member LLCs. We kind of went through that. We talked about how the bankruptcy court kind of eviscerated the protections and how Florida has eviscerated the protections. You will not be able to rely on a single-member LLC. In other words, if someone has liability, it is pretty good likelihood they're going to lose their single-member LLC.
So what do you do to fight against that?
Well, if you can add people, you add. If not, if it's a single person, you can, instead of owning directly the LLC, the single person can create an asset protection trust on it. And that creates a layer of protection. That's kind of as far as it goes, though. The next slide are these domestic asset protection trusts. So I had told you that they had a lot of offshore activity in the 80s. You can create your own trust. Now you can do it in 16 states. You have to basically form a trust in one of these states, Nevada, Delaware, Alaska. The trustee resides there, right? And it's a good idea for the assets to reside there too. Now, if a lot of people say, well, why would I put money with a trustee? I don't know. Well, you use a professional company trustee, and you have a protector. We mentioned protectors. So in your trust document, like if your client has hesitation on using an institutional trustee, basically we put his buddy in to say there won't be any distributions unless my buddy agrees. That's called a trust protector. Any questions on this?
So you can't move a building to another state. That's what you're trying to protect.
You can't move a building. That's true. Now we haven't had that case yet. I mean, if there's no claims and there's no litigation, and it's a single individual, you put the building in LLC.
So in an asset protection trust.
Right, but you got to put it in the LLC first. If something happens on the building, you don't want it to spread out to whatever else you're doing. And then that's owned by the asset protection trust. And there's nothing going on. There's no claims. It's a clear day. There is some likelihood it will. The case is the next case on the next slide called Huber. And Huber was a developer who built out quite a bit of the Seattle, Washington area. He lost, basically, he defaulted on his loan. I think it was between 40 and 50 million. He had an asset protection trust in Alaska. The problem is his assets were still in Washington, the co-trustee was in Washington, and he was in Washington. So he faced all these judgments in Washington, and Washington does not have a self-settled trust, right? Washington does not offer an asset protection trust. So there's a line of bankruptcy cases from years before that said, we don't offer it, right? You're here, everything's here, so we're going to view something like the Florida LLC, we're going to view your trust as if it was formed here. And they looked through it and they took it. The lesson from Huber is, if you're going to do the domestic asset protection trust, you have to do it right. You have to have the money and the trustee in the state who you form the trust. This is the most hilarious thing. The next slide is Henry Mortensen. So this guy Mortensen, he's like a mountain man type, and he's got acreage in Alaska. Sure. He formed his own trust in Alaska. But he's in Alaska. The trustee's in Alaska. It's kind of easy because it's all together, so it shouldn't be a problem, right? So I think he got a divorce. I think his wife realized this was going to become a breach. Because they're in Alaska. This is a real deal. Not only that, she filed a 4-year Alaska statute of limitations on fraudulent transfer tax. The fraudulent transfer is if I put money into a protected entity, right, and I'm running from somebody, they can go get it, right? But they only have a certain amount of time to get it. And I think Alaska's 4 years. It had passed. She was out. She wasn't going to be able to get the money. So this guy decided, no, I'm going to outsmart myself. He was in the clear and filed bankruptcy. In 2005, provisions were added to the bankruptcy code which say we are going to extend the statute of limitations on fraudulent transfer to 10 years. Brings them in the 10-year statute and uses all of them. What can you do? We have a couple in the next couple of slides. It says Bertrand potential issue number strict compliance. When you set these up, you have to be very careful to comply with statutes. Some require affidavits. Some require funding. You have to disclose certain funding. If you don't do it, the trust can be declared invalid. I keep wanting to offer that statute that's outside the window like this. Come on in. The next several slides, I didn't know how late you were, but the next several slides deal with sham trust, and maybe actually winning the game on asset protection trust. So in this Erskine case, basically you can't thumb your nose at these statutes. You can't say, I'm going to create a trust, I control it, I can take anything I want out of it. It's for me, nobody else is involved. That's basically what this guy said, but I did answer the sanction, you can't take it. So the court takes it. I mean, that's the Tennessee 2016. Surprise, surprise. Trustco was an interesting case. That's on the next slide. A Florida resident with 3 Delaware asset protection trusts got sued. And the debtor did something very, very insightful. So when you do an asset protection, you have a lot of banking relationships or creditors. You want to inform them of what you're doing. I'm doing protective planning. I'm planning these entities, right? You give them a spreadsheet. They put it in the drawer. What's happening? Now the statute of limitations is starting to run. Because most states have a discovery rule on their statute of limitations. Neither of them. For most states in the U.S. say, if you didn't know about the transfer, that statute stays open if you want to sue on fraudulent transfer until you know, and 4 years have passed. So if you tell your bank, and 4 years pass, not much they can do. So in this case, these people decided, the plaintiffs decided to sue in Delaware, where the asset protection trust was. That's a terrible mistake. Why not? It's just like Alaska, Delaware is going to uphold their own statute. So the Delaware court said, the debtor disclosed the trust to the creditor, and the 4-year Florida transfer statute is very well. And that's the end of the case. Anyone following me? Anyone have questions? Make sense? All right. Yeah.
Delaware or Nevada.
Yeah, and that's not a problem. That's not a problem.
Because other trusts will give you protection, irrevocable trust.
If they're for someone else.
If that's for someone else.
The interesting thing about the asset protection trust is you can create your own trust.
But can something be put in a trust and the income would go to person A and the assets would
can't go back
eventually go can't go back to the original.
No. You can go anywhere else.
But let's say husband has a property and upon death the trust will acquire to death but he wants his wife to have the income but not to sell the property can go to
somebody else,
to the children.
Oh yeah.
And then it's protected.
Yeah. Forever. No more estate.
And is there a difference to if you put it into a trust prior to death versus after death as far as step up in basis? So the husband owned the property for 40 years and there's no basis left. You should wait till he dies to put it into a trust.
That is a factor, yeah. Sometimes it's worth it. What happens is if you wait till you die, you get the appreciation and you might tip past the unified credit and have a taxable estate. Right?
Well, no, but if you're leaving it to your wife,
right, but
I don't know, or if you're leaving it to the trust, does it make a difference for the benefit
Yeah, I know what I heard that. So you have to decide, do I want to freeze out the appreciation out of these things and give it out and then give it away now and not get the step up? Or do I want to wait until that gets the step up, the fair market value, but I might have the estate taxes and things too high on the value. That's your issue. The next slide is this Kilker v. Stillman. This guy had done a pretty good job on the domestic asset protection trust. We went to California, the court kind of flailing away. I'm going to protect this. You can't get to me. You can't get to me. He upset the judge, and they somehow got to it. The law doesn't really support the case, but it's kind of an example if you don't want to go crazy in court. And he also reneged on the settlement rate, which stresses him. This next slide where it says 5, just goes through what I had mentioned. Excess control, alter ego. When they can't tell the difference between the grantor and the trust, like things are just going in and out. It's like the old corporation rules, you have to keep minutes, you have to keep your accounts segregated, you got to you got to respect the entity or the one you're respecting the court. The next one are sham. The sham trust is that means you created a trust to like suit somebody. Like it has absolutely no substantive value. Now, did you know that you could go to jail for not giving up assets? Does anyone know? Pretty interesting. You know what I mean? Because when you're a little kid, you're like, the English had debtor's prison. We don't have debtor's prison. But if you suffer a judgment, and the judge thinks you have assets, and you don't give them up, or you hide them, he can put you in jail for civil contempt until you give up the assets. It's happened a number of times. So this guy, Lawrence, he's a New Yorker, and he owed Bear Stearns. You see, he just should have waited. He owed Bear Stearns. He owed Bear Stearns a ton of cash. And he basically did what we call this fraudulent transfer. He had I think it was in the late 90s, he had 50 million, 45 million that he funded offshore trust with. This was before the days of domestic asset protection. He funded offshore trust with. He thumbed his nose at the judge. The judge said, "You're bringing that stuff back." He said, "I can't." Does anyone know why he said he can't? Well, the judge says, "I don't want to." No, because he's got a former trustee now that controls the assets. Former trustee says, "I'm not giving it to you." So he says, "I can't get it. I don't have the power. Look at the trust document." The judge says, "You created that problem. Bring it back or you're going to jail." How long? Does anyone know? Anyone want to guess how long he sat in jail? 6 years. Oh, wow. 6 years. 6 years. That's the longest ever. Yeah. Because it was the bankruptcy court. They have a lot of power. What happened? 6 years. 11 months. The rule is you can't coerce payment. You have to let them know. That's civil contempt. Still. So if you can try to coerce someone to pay, but if it doesn't work, you have to let them know. Which sometimes actually, there's a guy later here in the outline in a couple of months. They put him in jail for one night and they interviewed him in the paper, and he's like, "Okay." That's what's called the impossibility defense. You can't use that really. If you create the impossibility that the money can't be reached, they won't respect it.
It doesn't matter when you created it. You weren't liable.
It matters.
After you're liable for something, then you create it. Okay, that's.
And then there's a case in New York and in the Orlando area, BBT versus Hamilton Green. BBT is kind of botched that case, but it's an interesting case because the guy pleads that he needed this money for medical purposes for his family, and he had created a foreign trust. He had some pretty good arguments beyond that, but they let him keep everything. So you don't want to go in too brave. The next slide is number 6, foreign location. So this is a comparison, foreign versus domestic. So foreign trusts are very expensive. They're very expensive to form, and the annual fees from the foreign trust is quite expensive. So people ask me, well, what kind of money should I have before I want to consider foreign trust? Well, it's not like there's no amount, but it's going to cost you, you know, between $15,000 and $25,000 to form it, and it's going to cost you about $5,000 a year. So you're probably not going to put $100,000 in there. Also, it can be very bulky. We use a Swiss banker. We refer to a Swiss banker. We used to refer to some of the people in the island. It can be very bulky. You know, this is not like, you know, where you're walking into Goldman Sachs and you make the true place in order to this type of thing. I mentioned before, we use it usually for a small amount of money in relation to the client's overall deal. But it's a bombshell. I mean, it's really tough to reach. The domestic is that there's more exposed because the asset's really deep in reality. If you live in the state offering, the domestic asset protection trust is very strong. Or if your client decides, I want one, I'm going to open an account in that state, in whatever, Delaware or Nevada, and I'm going to use it as a trustee in that state. It's pretty strong. It's pretty strong. And of course, not everyone is comfortable with putting money offshore.
In the foreign trust, if you have no rights, you don't have to file the left one, right?
It's not, you don't.
Well, if you have any rights, as a beneficiary or
well, you have to file as a beneficiary. I think it's 3502. So it's a different filing. FR is just an account. But if you don't own the account, it's a truly foreign trust, it's not a domestic trust. No, I don't believe the file. It's almost the same file as beneficiary. Does anyone know what the full faith and credit clause of the U.S. Constitution is? It's basically, if I get a judgment in Florida, I can enforce it in the state. Right? So if I get a judgment in New York, can I enforce it in Nevada against the Nevada trust? I can try. But if the trustee's in Nevada and the asset's in Nevada, I'm not probably not going to get through it. Because the Nevada trust will prevent access. Just something to keep in mind. What are you doing on time? How late is it? Should be 8:30. 8:30? You get credit? All right. You tell me. You just tell me. The next slide is, how does a U.S. court reach into foreign trust? I mentioned this Wells Fargo case, which is the LLC case with the Super LLC. Here's an interesting case called Sargent. So in the Sargent case, it was a defendant from the United Arab Emirates gets sued on a construction matter, and he loses. And at the end of the case, El Salah, that was the defendant, says, well, I lost, but my stock certificates are in the Dominican Republic and the United Arab Emirates. So you take your win, your judgment, but you've got to register it in those countries to reach my stock. Right? So in some other cases, the judge would say, okay, you need to bring those shares back or put me in jail if you lost the case. This judge went right by the book. Non-bankruptcy judge, state law appellate judge. Said, no, he's right. If you want that stock, You got to go to those countries, register your judgment, and get it. So basically, El Salvador will likely win that because it's wildly expensive there to do that. So what do you get out of the case? You should issue your stock in your LLC, and the reality is, if you want a really protective aspect of that LLC, it should be held somewhere that's protected, right? Because it's just winning the judgment, and they're going to do it. You got to go to the jurisdiction where the stock is held to get the company, and that's the law in Florida. The next page is kind of a survey of some of the advantages of certain foreign trusts. It's in the book. What you see on some of these advantages and aspects of the foreign trust is they talk about the fraudulent transfer statute limitation, right? Because one of the main claims of when you're looking to get somebody's assets is they moved it. I was trying to get the asset, they moved it away from me. And in most states, you have 4 years to get it. Whereas in these offshore trusts, you might have 1 year. You might have 1 year plus you have to prove insolvency. You would say, no. The guy was in Florida when he moved it into the trust, so we're going to Florida law applies. 4 years applies. And they'll say, no. We only apply the law of our jurisdiction to these trusts. So there's these protected aspects which are just really gravy beyond the fact that anything you put into a foreign trust is going to be beyond reach of the creditor because the judge has no jurisdiction. Some of the aspects are on the next slide, selecting trustees and protectors. So what we don't want to do is find a trustee like some guy, right? Because you hear these stories like, well, we found a trustee in Bahamas and nobody knows who he is. That's not good. You want to use an institution that has billions of dollars in trust assets, and then you want to appoint a protector. But just in case somebody goes off the ranch as a trustee, you've got a protector that says, no, I veto that distribution. You're not stealing from the trust. And you go into your banker, and the banker has the sign-off form and the checks and everything else require 2 signatures so that no one can get any assets out of that form. There is a note here that's a pretty good point. Trustee friends can be entwined with litigation, right? So that works 2 ways. How many times has someone said to you, I'm going to give it to my cousin. I'm going to give this property to my cousin so that I don't lose it in litigation. We haven't been on business all the time. Well, now what have you done? You've entwined your cousin in the litigation. So you're going to lose your case, and then they're going to have a big deposition trying to figure out what assets you have so that they can take them. And they're going to take your cousin, and then you're going to pull your cousin into deposition, who now has to give up the asset, and there may be costs and expenses. It's just a bad thing. And the same can be true for the protector and trustee. If in fact the trust goes into some kind of litigation, your friend trustee or your friend protector would have to do this. And D says, will the trustee manage investment? It's not required that the trustee manage investment. The trustee really can be limited to his discretion over distribution. So a lot of times the client will say, well, I will have my financial plan to allow him to manage my investment. Both under the domestic asset protection trust, the LLC, and the foreign trust. Now, if you haven't gotten to sleep yet, this is the best part: tax consideration. Like, who in here is a tax CPA? That's it? You got one? You got a couple? Half and half? Do you ever do any foreign tax work?
No.
Nothing. It's really an additional layer on the code. It's whether money coming in, money coming out. So there's a little background here. That's pretty good for you if you want to move back. One thing to keep that's very interesting about the international tax law is that you can be a resident for income tax purposes, right? But not for state tax purposes. And you can be a resident for state tax purposes and not income. So when we look at income tax, we talk about substantial presence. So the way it's not on the basically the way you figure out whether you're a resident for income tax purposes is the amount of time you spent here. So they take 3 years and they do a weighted average, 3, 2, 1 for this year, the prior year, and the year prior, right? And they add it up, and if you're here an average of 183 days, then you're a resident for income tax purposes. Or if you have a green card, you're a resident for income tax purposes, even if you're not here. So, what does that mean? That's federal. Yeah. I am not a New York State tax license. That wasn't obvious. So, what does that? That means that you're taxed internationally on all assets, right? Now, that's crazy if you're a U.S. citizen, but it's more crazy if you're here and you're not a U.S. citizen and you think your home is somewhere else. When you have to start paying tax when you sell your property in Indonesia, or you have to sell your, ranch in Brazil, and you've been here a certain number of days, and you have to pay the IRS on that sale, that's an eye-opener. It's an eye-opener. Minus farm tax credit. The estate tax is for domiciliary. Now, it's not based on a number of days. It's not a weighted average. Did you land here and do you intend to stay? If you landed here and intend to stay, your entire estate, no matter where it's located, is subject to U.S. estate. Okay? I could read that 100 times. It doesn't really make sense. But it's true. There's some exceptions here. Non-U.S. persons on the next page. There's some really interesting exceptions to it. Did you know that foreign people who are not residents here for income tax purposes can buy and sell on our stock market free of tax? Did you not? Yeah. If you buy and sell stock, right, in a U.S. company, and you're not a U.S. resident for income tax purposes, you're not paying. Isn't it fascinating? All these years, you would have immigrated already. True thing. And it's all they can do not to become income tax residents. I mean, if you got people here, they're like, oh, we're just visiting, we'll be gone tomorrow, because they want to be here, but they don't want to stop getting these freebies on the stock exchanges. There's a reason. They don't pay that. Treaties, many countries have treaties with the U.S. which limit the double taxation. And then SEDAPI, have you heard this word, SEDAPI? That means if you have income derived from someone that gets 30% less on a net income, that's subject to withholding. You can make an election to treat the property as if you were a U.S. person, and then you can take deduction. And typically, if it's a rental, there's a lot of deductions you might We go to the forward trust. The forward trusts are it's very complex. Probably somewhat beyond the time we have here. We're going to run half hours. The most interesting thing about the forward trust is that in the Obama administration, what happened was people were using foreign trusts to save tax. There was some slight savings in certain ways. You could manipulate a foreign trust. So they passed a little law. I think it's 684. They passed a law that said if you start a trust for yourself, it's grantor disregarded. Is everyone aware of this grantor trust rule? It means that the trustee is ignored for tax funds. It doesn't exist. So Obama says, no more playing around with trust. If you form a trust and you're a beneficiary, it doesn't exist. So there's a lot of layers of complexity. I'm not sure I'm going to give that decision, but it eliminated a lot of layers of complexity. Because now, all your U.S. people, if they form a foreign trust, just disregard it. There's no way around it. And then there's a couple notes here. You know, if you're an income beneficiary of a foreign trust, you've got to report the income, obviously. The next page says the transfer taxes, which are gift taxes and estate taxes. In people that are not citizens or residents of the U.S. have to pay a state gift tax on U.S. assets. Okay? So if you've got the Brazilian that owns a condo in Manhattan, and it's kind of probably not a great example, it's a condo in Manhattan, sells it, you're gonna have, or gives it to his kids, gift tax, dies with it, estate tax. So does everyone know that current exemption, husband and wife, $22 million? Very popular compound. $22 million, right? $11 million per spouse. What if the foreign exemption? What is the foreign exemption? If you're not a U.S. citizen or resident and you have money here, you're subject to estate tax on those assets. You know what you get as an exemption? $60,000. So you don't want to be holding things in your own because you got to pay taxes almost every dollar for it. This is a stupid thing though, because if you form a foreign corporation or a foreign LLC that's taxed as a C corp and it owns U.S. assets and you're not a resident, there's no safety. I'm sure you guys have come across from time to time as foreign entities and they own a piece of property, they have their own business in the U.S. There's a guy shuffling in and out of Manhattan or whatever. It's because if he owns the corporation and it's a C, it'll be C by default in this case. When he dies, there's no tax. There's no safety. So it's a real error when someone comes in if they own something in their own name that has any value. Right? If they're not going to be a resident or citizen, they only get $60,000 exemption, and the rest is taxed. I had someone come in a couple months ago. They bought a $2 million house, and it was really like a tragedy. They bought a $2 million house, and they took it husband and wife died, and they were not residents or citizens, so they don't get the transfer without the credit. Right? So on half the value they had to pay $400,000 tax for 60 million. That's totally avoidable. The one thing about the foreigner that's another example. It's kind of like buying and selling stock for free. They can give away intangible assets and no gift tax. We cannot do that as citizens. So if they have stock in a company or anything intangible, they can give it to anyone they want, and there's no give back. It's an exception. That same asset, though, if they die with it, there's a stake. So there's a lot of planning. There's a lot of planning to do before we do it. The next slide is, when is a trust a foreign trust? And it's kind of a technical thing, basically. If there's a foreign trustee, or the court really cannot make a judgment on affecting the trust, it says you must meet both these steps to be domestic. So if it has a trustee, or there's some kind of problem in terms of the governing law, it will not be a domestic trust. Now, there's some advantages to that. We don't do it much, but if you're foreign, right, and you plan and you have a foreign trust and you want to keep it, because all your assets are there and they're sheltered. You want to be U.S. You want to come to the U.S. You don't want to bring all your assets, because then when you die, you're taxed. We retain its foreign nature, and you can even buy U.S. assets. So you keep a foreign trustee, right? And you may even move that trust from Cook Islands to Delaware. But the foreign trustee will retain the status of that trust as a foreign trust. It's really holding up to sometimes. Not that many people want to come in and risk bringing everything in. It does come up sometimes. The next slide is grant for status. I had mentioned, it's 679. I had mentioned the 679. Boughman said if a U.S. person forms a foreign trust for the benefit of himself, it's disregarded. It's granted. There's some twists to that. One twist is, upon the grantor's death, there's a deemed sale of the asset. Deemed sale. Where does that come from? Does anyone know? Has anyone ever heard of the exit tax? I know I'm the only one on earth doing this. I know. But when it comes up, you call me. That's what we do. So the exit tax is, Clinton formed the exit tax originally. So what was going on was a foreigner would come in and build up a huge business, right? He'd leave for a while. He'd not be a U.S. resident, and then he would go, and then he would slip under the I get to sell stock for free rule, right? So he'd come in, he'd build a big business. He'd leave, he'd sell the thing, no tax. Couldn't have been like that at all. So in exchange for some other legislation, like 1980, he got the exit tax. And the first iteration of the exit tax. So the first iteration of the exit tax was much more mild than it is today. It was something like, if you leave and you sell within a certain 10-year period, then you're hit with this tax. But it eventually, once it got to Obama's desk, it was mark to market, which means it was first based on citizens. Any citizen who leaves and expatriates rights from our country is treated as if they sold all their assets at fair market value and have to pay the capital gains tax right now. That's the exit. It's pretty interesting. This little number where it talks about a grantor forms a foreign trust and it's disregarded for income tax purposes, but when he dies, there's an exit tax, which is pretty crazy actually. Unless those assets are included in his estate. So really, what's going on is there's an exit tax when you die, or if you gift out permanently. So the complexity of this is you can create the trust and it's disregarded for income tax purposes. So as it makes income, you have income disregarded, it's just you, but not for estate and gift tax purposes. So if you decide, I got this building and it's going to double in value, and I'm going to put it in a foreign trust, right? It's a permanent gift. It's out of your estate. But as the building makes money, you have to pay income on it anyway. If you do that, you have to pay gift tax, which you have to pay anyway, which is just like the estate tax for the value of the gift. And you have to pay the money. You have to pay as if you stole the profit. 2 taxes. I know, yeah. And it's not typical for U.S. grantors. So what you guys are going to find typically is somebody who wants to take a portion of their assets and do a bond shelter. And the point is that they can do whatever they want. It's going to be disregarded for income tax. It's just like a theft. That is disclosed, but there's no tax shock. It's just for protection. We've got some more rules here, but U.S. beneficiaries must recognize trust income. And I don't know if you go hard on the rollback rules, but they'll make you throw up. And then, like, if they're not made, if a distribution isn't made, and the trust is paying the tax, and eventually upon making the distribution, there may be an accumulated income tax for beneficiaries. You can split your risk trying to re-benefit. It's fairly important if you want to plan around U.S. beneficiaries. So the next one is pre-immigration plan. And I will take you through, that'll be it. Just let me know whenever you're ready. Basically, the last thing you want to happen is for someone to come into the country and bring in, last time we had this, these people had like $300 million in assets, right? So they bring the assets in, and when they go, they've got to pay $120 million. You can't, basically they should do whatever they can to avoid that from happening. It's just not, that's not part of the plan, I can guarantee you. So if you complete the gift, if they say, okay, I'm going to form a foreign trust, a real foreign trust, and I'm going to fund it up with X percentage of my assets, they have to wait 5 years. Almost no South America, depending on the country, very few people could plan on 5 years. But that's the rule. If you wait for 5 years, and then you come in, it stays out of your estate. If you don't wait for 5 years, it's as if you bring the assets into the country on the day you're right. So it's a great planning idea. The hard part is convincing the client to wait 5 years. They can come in, they just can't be domiciled. They can visit and everything else. You sometimes I'll go through these long analysis with people. You can't come in, you got to stay out, do this, do that. We did a lot of this Portugal had this deal where they could go to Portugal for the 5 years, and they got a tax-free period. Like they paid no tax in Portugal, and they could expatriate from Brazil, and if they later wanted to come to the U.S., they could with this foreign trust strategy. So some of them are doing that. And you see these mansions in Portugal going on. No one knows where they're coming from. That's where they're coming from. The next slide is grantor treated as owning the property. So this is the same rule. They have to wait 5 years to come in. Upon the 5th anniversary, deemed contributions, if they come in prior to the 5th anniversary, deemed contributions as of the residency. So I'll take the last 10 minutes or so, wrap up, and then we'll have confidence or questions or however you want to do it, or just ask me whatever questions you have. We have about 10, 15 minutes. It says keys to effectiveness. So basically, what these keys to effectiveness deal with are not the foreign trust. The foreign trust is going to work because the courts struggle with this thing. One issue with foreign trust, I would say, although we recommend that only a portion of the assets go into the foreign trust, what do you think happens when the judge says, I can't get to the foreign trust? They look to the other assets. There's been a lot of divorce cases, like where, you know, one spouse has a foreign trust, and the other spouse says, look, you've got all the assets in the foreign trust except the building, right? And the building was premarital property. So the spouse can't get to the building, and the assets in the foreign trust are completely blocked off. Somehow the judge gets to the building. What happens in the marital settlement. And these schemes to effectiveness really come down to the cases we talked about in terms of the domestic asset protection trust. Where are the people? Right? So in that Huber case where he got sued and he was the contractor, you know, who owed millions of dollars to his clients, the banks, a number of different creditors. He had his trustee in his state, Washington, asked for his state, and he was his state. So that's the last situation you want to do. If you decide, you can call me anytime, you talk through any of these issues. If the client decides, okay, I'm going to do the Nevada trust because I don't want to go offshore, and I'm a single person or something like that, well, they have to know that the optimally they're going to invest in an account that's in Nevada, and their trustee is going to be in Nevada. Because otherwise, you're going to get the situation you got with the Florida Law Party, where the court is going to be tempted to break through the trust and just take whatever. So it says there's either where are the people, where are the assets. You have to really respect the trust. You have to really respect the policy of the trust. Use the law of the jurisdiction and use the people there, so that you can apply that extension. We have excess control. We have a tendency to improve and retain excess powers. It looks like it's just you. Let the trustee decide on distribution. The trustee can't take the money. The trustee always gives it. Avoid bankruptcy. Why do we avoid bankruptcy? So bankruptcy is discharge of indebtedness, right? You go in, you're insolvent, right? You say, I'd like to give up what I have so that you take away the debt. A fresh start, right? Now, bankruptcy has some of the exceptions that I mentioned to you for LLCs, for assets that are protected, but bankruptcy courts are not in this around. If they think that you're doing a fraudulent transfer or that you're taking advantage of the system, they have much more discretion than the state court. And a lot of these cases where they go through trust and LLCs are bankruptcy. Bankruptcy is really a last resort. Bankruptcy is not really intended for you to keep alive. It's really a discharge of debt. People really run into problems. The one guy in Alaska, he wouldn't file bankruptcy from me, have all this problems. And now we go back. We're going to go full circle with the crypto. At 8. So you can print your Bitcoin crypto key or key is private or public key. So these things, if you lose the key, right, you're out. You lose the key, you can't get to your Bitcoin account. So you have the key here, right? And my partner Eric does the same. You can't get a big one. He tears it in half. And he gives half to the trustee. Right? So the trustee can't really do anything. He can't really do anything with his half. And so when someone brings a claim and they try to reach to the trust, what do they get? Half. kind of strange. It's like a little intellectual puzzle. If you ever wanted to protect yourself and you were there with the trustee and you give them half the keys, well, the trustee can't really do anything. Yet, neither can you. Right, neither can you. And the judge will put you in jail for you get the two pieces together. That's your issue. Put them both in jail, you know, comes up with the key. Yeah. And then we have this last page. Issues, concerns, comments, intentions. So does anyone know what the only anonymous LLC jurisdiction is? At the end, what's an anonymous? What is it? What is an anonymous LLC? You know, you can file the LLC, right? And then, you know, when you look up an LLC, it shows who the managers are, who the members are, that kind of thing. Delaware doesn't. You can file in Delaware. The only thing on that thing is the registration. Yeah. It's anonymous. It's not illegal. It's just anonymous. You just can't find out anything about the person if they do a Delaware LLC.
No address of service.
The registered name, friends. He's a, you know. We could take a couple of these issues. Hiding assets versus conveying ownership. Legal compulsion. That's this loans versus terms. What does the future hold? Investments using cryptocurrency blockchain technology. What does that hold? Blockchain may survive. I don't know if cryptocurrencies are really going to be here in 10 years, probably 1 or 2. But the blockchain looks like it's going to survive. That's actually a technological breakthrough. Prediction is very difficult, especially about the future. I thought that was Yogi Berra. I see the guy down here, Robert Storm Peterson. And then we have one on the here. You guys have any questions or anything? Before.
The best way to structure trust, or a lot of times only people structure trust to protect the house, but if they're going to Medicaid or if they're going to nursing homes, the house can't be taken.
That is not asset protection. Actually, that's a great point. That is elder law. You ever heard of someone who specializes in elder law? That is the preservation of assets by someone who's going to get public benefit. So what they do in elder law, we don't do elder law. What generally is done in elder law is there are exceptions for assets that you can retain that don't affect your formula for public benefit. And I think the house is one of them. And then there's a threshold of like a couple $100,000 in the account, and then the rest of it you kind of give to your kids and take your public benefit. Yeah, I'm not an expert at that, but it's a similar area, and we get a lot of questions on it. We deal with people who like are terrified that if they're sued, they're gonna lose their fortune. Elder law is like similar, but they just don't really want to lose everything just because they got old. You know, I think it's a good question. Anybody else have any questions? We want to make sure you get credit. Are we going to say something? Yeah. Okay. All right. Thanks so much.